my ears are stuffed up, so talk loud because we don't have any microphones here. And first of all, I want to welcome you. And I first want to say that if anyone wants to speak, would you stand now so we could say the pledge? We're to tell the truth, the whole truth, and nothing but the truth, so help me God. Thank you. Okay. So the other thing is I ask all the time, please, councillors, everyone, put your phones away, shut them off in respect to the nominee. So having said that, I would like to start with first calling on the nominee. Welcome again, Attorney Pineault. Would you introduce the people here that have come to support you?
Yes, thank you. Good morning, everyone. Michael Pineault, and here to speak on my behalf are Devaney, Councillor, and Laura Martin. And here in a non-speaking capacity, but far more important, is my wife, Heather Pineault.
And in the governor's chair?
Yes, we have just Brieger, I'm sorry.
So I'm going to begin by having you introduce your witness, and your first witness is David Mackey. Am I saying it right, Mackey?
Yes, that's correct.
Why don't you sit down and tell us what you know about the nominee?
Good morning, members of the Governor's Council. My name is Dave Mackey. I'm a lawyer at Anderson Krieger here in Boston, and I want to thank you very much for the opportunity to say a few words about Mike, and thank you all for your service to the Commonwealth. I've had the really distinct pleasure of working with Mike twice in his career. 4 years in the Civil Division of the U.S. Attorney's Office, and then for the last 3 years at Anderson Krieger. And I know Mike well, and I say with absolute confidence that if confirmed, he will make just an excellent addition to the Superior Court bench. I know I don't really need to labor here Mike's academic background or his legal skills. Mike is a gifted thinker, and advocate, and writer. He is truly one of the smartest lawyers that I know. And I know you've seen his resume, and it obviously reflects that. He wrote a very important pro bono brief for the American Cancer Society in an important case to the American Cancer Society. And he worked with a senior colleague of mine who, to say the least, is a gentleman who is exceedingly difficult to please. And the day after the brief was filed, that colleague sent an email around the office, and it simply said, "This brilliant brief is Mike's brainchild." And coming from whom it came from, that was really the highest praise you can imagine. I want to talk most about two things: Mike's breadth of experience that brings him here today, and his really great skill as a listener, which I think is just going to be an asset to him on Superior Court. On breadth of experience, I did some mathematics looking at Mike's resume. He's got 14 years in the public sector practicing law. He's got 19 years in the private practice of law. Or counting another way, he's got 11 years doing civil work, 8 years doing criminal work, and 14 years doing a lot of both. This breadth of experience is going to serve him really so well, managing the incredible variety of challenging matters you see as a Massachusetts Superior Court judge. Mike is absolutely a person who's going to be ready to go on day one, no matter what the case is. The next thing I want to talk about, and really probably spend the most time on, is Mike's skill as a listener. This skill is going to give Mike just, I think, the ideal temperament for a son. Whether it's Mike's clients his colleagues. Mike has the patience to listen. He has the patience to pay attention. He's considerate. He asks questions and so he can understand. We were together on an extremely complicated, hard-fought civil matter. It was acrimonious breakup of an LLC. The LLC owned a number of apartment buildings in the Boston area, and our client was a very savvy, very experienced real estate developer. We spent so many evenings talking to this client, listening to the client, understanding his business, what he was really concerned about, what was important to him at the end of the day. And that was really important. The case ended with a mediation, and the other side was represented by one of the best and one of the toughest lawyers in the city. Mike wasn't getting pushed around, but at the end of the day, the mediation was successful, not just because Mike's a really skilled advocate. As so often happens in these mediations, there are a lot of very difficult and tough conversations with the client. And the case settled because Mike had listened to the client, he understood the client's concerns, and because of that, the client fully trusted the counsel that Mike was providing. And at the end of the day, the mediation was successful. We walk out of the room, and the client gave Mike a big hug. And I'll never forget, but that gesture just spoke volumes to me about my skill as a listener. From my perspective as a litigator, being a good judge involves so much more than just, being smarter, knowing the law. Mike has that for sure. It's just so important for the parties to know that they've been heard. That's especially important for the party that doesn't come out on top. And with Mike, I know that the parties who appear before him, whether they win, whether they lose, whether it's a draw, they'll know they've been heard. And I just think that's just super important. So Mike he's just so gifted, so hardworking, with an amazing breadth of experience and a talent for listening and understanding. Those are the qualities that make me and my colleagues so grateful that he's spent the last 3 years of his practice with us. And that's why we're really going to miss him if you choose to confirm him to the Superior Court bench. So thank you very much, councilors, for listening to me this morning. And thank you again for.
Any councilors have questions?
Real quick,
Councillor Iannella.
you mentioned mediation, but in fairness, 99% of cases resolve. All right?
Well, mediation, in the civil context, yes, most cases settle, sometimes short of mediation, but they. My experience is, well, maybe it's more than 50-50, but not, once they get to mediation.
Mediation.
Still no person speaking.
Yes, I think it's fair to say that more than half of the cases that go to a formal mediation settle.
Yeah, we do mediation probably once a week. We know all the mediators. They all brag about, oh, we're 92%, we're 94%. They're not a secret. Thank you.
Any other councilors? Thank you very much. I just want to ask just a simple question. You've known this nominee how long?
We met in probably 1995, I think, when you started the U.S. Attorney's Office, 96.
97, actually.
Okay.
Well, so you know
97.
everything about him professionally, personally. What quality you think brings out of all his qualities? What is the main quality that he's going to bring to the bench?
I think it was the quality that I mentioned when I was talking, Mike's capacity as a listener. I've spent so much time since Mike arrived at our firm trying to deal with a difficult situation with a client or a case. I have made it a habit to go into Mike's office, close the door, explain to him what's going on. And Mike has a way of conveying to you that he's listening, he's trying to understand, and we know that he's understanding because he invariably gives really good. I've benefited enormously from that over the last 3 years.
Good. Thank you very much. Councillor Duff has joined us, and now I will go on to your next witness. Thank you very much.
Thank you.
Laura Martin, welcome.
Thank you. Thank you all for providing me the opportunity to speak in support of Mike Pineault's nomination. My name is Laura Martin, and I'm a fourth-year litigation associate at Mintz Levin. I first met Mike back in 2012. He hired me as the office manager / paralegal of his small firm. And after I left that position to attend law school, Mike has remained a key mentor to me since that time. I truly enjoyed my experience working for Mike at Clements & Pineault. I worked at the firm shortly after I graduated college, so this was my first full-time job. It was my first administrative position. And there were no lawyers in my family. I had no idea what to expect. And the entire time, Mike was exceedingly patient with me and very understanding with me as I learned my role and got up to speed. And eventually, he provided me more additional opportunities that made me decide I want to go to law school and be a lawyer. Looking back, I have nothing but positive things to say about Mike's treatment of me. He always dedicated time to ask about my family and things outside of work, and he likewise shared his experience with his family, their amazing vacations, his daughter's activities, and I loved talking with him about our favorite topic this time of year, decorating for the holidays. I always observed him being nothing but kind and patient to me and to others. Lawyers, clients, the building maintenance staff, the delivery staff. He was always kind to everyone. About 3.5 years after I left, after I was at Mike's firm for 3.5 years, I decided to go to law school at Boston University. And for various reasons, it was actually a very difficult time in my life, but I made it through mainly because of Mike's support. He was always patient and kind when I called him. And I am mortified to say this today, but I would call him unannounced in the middle of the workday, and Mike would always answer and give me hours of his time to counsel me. And it wasn't just counseling me and providing me advice about picking classes or dealing with professors or trying to be a competitive candidate after I graduated, but it was giving me significant support and encouragement to continue through and push toward my goal, even when things were difficult. In addition, Mike has also introduced me to other key members of the legal community that have been very helpful for my personal and professional growth, both during and after law school. As stated, as a mentor, Mike is incredibly selfless with his time, and his calm demeanor is great at bringing others at ease, including unnecessarily panicked mentees. Excellent listener, he's incredibly thoughtful, and he always has provided me with well-reasoned advice. And to conclude, he's been a guiding light for me for my entire professional career. I've known him since 2012. And I have no doubt that the patience and kindness that he has shown me during this time will easily transfer to his role as a judge. He is a brilliant lawyer, he exudes integrity, and he has an innate sense of fairness. But his most remarkable asset is his patience and kindness to others. I have no doubt in his ability to manage the courtroom. I have no doubt in his ability to be reasonable and fair to all litigants, and I have no doubt that he will be a truly amazing judge. Thank you for your time.
Thank you. So, so you see Attorney Pineault every day, or?
When I worked for him for about 3.5 years, I would see him every day. And then in law school, we still maintained in touch. And I've been a lawyer for 4 years, and I still rely on my advice.
Any councilors have any questions?
Council. You talked at length, so I'm kind of guessing what your answer is going to be, but during the time that you did work daily with our nominee, did you ever see him lose his temper or get short with people or, stress-based response that was less than patient and kind?
No, not at all. Even if there is a stressful situation, he can maintain a calm demeanor throughout.
But thank you, I appreciate it.
Thank you.
Any other questions? No. Well, thank you very much. Appreciate you. Our next witness is Jonathan Councillor.
Up there, yes. Good morning.
Welcome.
Thank you. Good morning, honorable members of the Governor's Council, and thank you for the opportunity to speak on Michael Pineault's behalf. I too have the honor of speaking for him in support of this confirmation to the Superior Court. I cannot think of anyone who is better qualified to sit on the court. Michael is a great lawyer, as you've heard, but even more importantly, he is a truly fine person. In addition to all his accomplishments, he is humble and kind and compassionate. I first met Mike when we worked together in the United States Attorney's Office. In 2001, Mike was assigned to the Economic Crimes Unit, and at that time I was chief of the unit. I therefore was a supervisor and remained so for the next 4 years until I left the office. My first memory of Mike, when he came to the Economic Crimes Unit from the Civil Division, was this intense interest in continuing to work on a case he had worked on in the Civil Division. That case involved the government's lawsuit against movie theaters to compel them to provide better access to disabled patrons. A movie theater chain had built several theaters with medium-style seats that essentially provided word seats in the house to the persons requiring a wheelchair. Usually when an AUSA switched divisions, they would leave their current caseload behind and start with a clean slate. Mike, however, was adamant about seeing this Americans with Disabilities Act case through to the end. As chief of the Economic Crimes Unit, I tried to encourage Mike to leave that case behind. I didn't want him to take this new slot and work on a case that he had in a previous unit. However, I was struck by his passion and his persistence to continue to work on this very important case. It ended up being a case where Mike's talents and his commitments to righting a wrong made a huge difference in the life of people with disabilities. Throughout the almost 4 years during which I supervised him, I was continually impressed by his commitment and diligence. He always worked very hard and performed outstanding. In a group of very talented lawyers, his written product stood out. He's extremely bright, he writes beautifully, concise, clear, and convincing. He was also an excellent courtroom advocate, both in legal arguments to the court and before a jury. He's very articulate and very credible and presents extremely well both to a judge and a jury. I observed him on trial several times. He knows his way around a courtroom and was always a consummate professional. As I said, beyond being a fabulous lawyer, he is also a very fine person. He is honest, fair, and compassionate. He was never a prosecutor who looked to get the longest possible sentence. Rather, he was very measured and tried very hard to be fair and reasonable. One of his most successful prosecutions as a federal prosecutor, it was not the conviction after a contentious trial of the lead offender that is most telling about Mike. Rather, what is most telling is that he listened to a lawyer for a colleague of the lead defendant who argued that his client's circumstances were so extraordinary that he should not be charged. Careful consideration, Mike recommended that this person not be prosecuted. I am sure that he will bring the same compassion and care and excellence to the Superior Court bench. I suppose the strongest recommendation I can give him is to say that in situations when I have needed to refer someone to an attorney, I have not hesitated to refer people to Mike. Since he left the government to return to private practice, I've referred potential clients to him. I have done so because he is an excellent lawyer and will provide excellent representation. In one recent case, he took the lead for a group of defendants in a False Claims Act case, arguing a motion to dismiss before Judge Talwani in federal court. He was simply outstanding. He engaged respectfully with the court, but did an excellent job zealously making his arguments relating to a very complicated legal issue. In short, I think Mike is a complete package and would make an excellent Superior Court judge. And if you have any questions, I'm happy to answer them.
Okay. Any questions?
Thank you. Thank you.
Yes, you answer them all. So, so I just want to know, when you saw him in court, what impressed you about his, how he represented his clients?
He was always a zealous advocate for his clients, but he was always very respectful to the court. And as Mackey indicated, he's a very good listener and he would make very good arguments. And he really came across as just the very decent person that he is.
Those are good qualities. Well, thank you very much for coming. So now that we've heard your witnesses, it's your time, and we'd like to hear from you.
Thank you. So good morning. I'd like to begin by thanking everyone.
I'm going to ask you to talk up. I'm sorry.
Sorry. I can be soft-spoken at times, so I will try to speak up. I'd like to begin by thanking everyone who devoted so much time to reviewing my judicial application and meeting with me both in person and by phone. That obviously includes each of you as members of the Governor's Council, but I also want to thank Valerie McCarthy and Governor Healy, Lieutenant Governor Driscoll, Scott Reed, and Dara Kesselheim from the Office of the Governor's Legal Counsel, and the members of the Judicial Nominating Commission. I very much appreciate the seriousness and the care displayed by all of you at every stage of this process. Turning to the substance of my remarks, I thought it might be most helpful for me to begin with the personal rather than the professional and tell you a little bit about my family. My mother came from an extended Portuguese family that lived and worked in the Taunton area. Her mother was born in Madeira, Portugal, and emigrated to the United States with her parents when she was quite young. The second oldest in her family, she had to drop out of high school because her family needed the money she could earn as a maid and a nanny. My father also grew up in southeastern Massachusetts in a French-Canadian community in Swansea. His father was a milkman. For my parents, education became their springboard. Both attended the University of Massachusetts, my father on an Army ROTC scholarship. After graduation, he served in a tank battalion based at Fort Lewis in Washington. My parents instilled their beliefs about the value of education in me. We were not wealthy, but we had enough, and my parents made a promise. If I worked hard in school and contributed as much financially as I could, they would do whatever it took to make up the difference so that I could attend the college of my choice. My parents honored that promise. They borrowed as much as they could, and that combined with some scholarships, personal savings, and financial aid loans that I was able to take out myself was enough to get me through college. I then financed law school myself with a graduate school fellowship, more loans, and earnings from various jobs. I share this story not because it is unique or because I think my childhood was more difficult than the other kids I grew up with in Foxborough, but I think it's important for people to know my roots because they define who I am and who I will be if confirmed to the Superior Court. And they are the roots of a person who was raised and remains very much grounded in the real world. That is true for my family as well. My wife, Heather, who is here with me today, is a public school teacher and a member of our town's Human Rights, Diversity, Equity, and Inclusion Committee. Our oldest daughter, all of our children are now grown adults. Our oldest daughter is also an educator. After teaching for a few years, she's now in graduate school, studying how the human brain acquires language. Our middle daughter lives in a small town in Vermont, works as a cross-country ski instructor in the wintertime, a kayaking guide in the summer, and a graphic designer for a small outdoor sporting goods store in Montpelier, Vermont. She's inherited her father's love for the outdoors. And our youngest daughter works in an Arlington preschool as a teaching assistant. With respect to my own career, I have tried in my own way to make a meaningful contribution using my law degree. Those efforts began at the first firm I worked, Hill & Barlow, where one of my earliest cases involved helping families obtain necessary care and services from the state for family members with developmental disabilities. My efforts continued at the U.S. Attorney's Office. You've heard about the civil rights enforcement action that I filed, working closely with attorneys from the Civil Rights Division in D.C. to protect the rights of people with disabilities to have equal access to places of public accommodation. That case lasted a number of years. After 10 years at the U.S. Attorney's Office, I joined the governor's office when Governor Patrick was elected. He and I had been together at Hill & Barlow many years earlier, and I served for 3 years as his deputy chief legal counsel. After returning to private practice at Clements and Pineault, I represented clients in 2 substantial matters, again spanning many years at reduced rates and ultimately for no charge. Those were both criminal cases. And then at Anderson and Krieger, and Dave has told you about a Supreme Court brief that I recently filed on behalf of the American Cancer Society and several other public health organizations in a case that could, depending on how the Supreme Court decides it, have a major impact on people's access to health care. What all of these cases and my experiences over the years have taught and reinforced is that the law fundamentally is about people. And those people need and deserve a judicial system that treats them with compassion and respect. That is true for every person in every kind of case I have ever handled, large or small, civil or criminal. It was true for the families in the first case I described, who never forgot Judge Toro's willingness to visit and see for himself more than once the conditions at the state-operated schools where their children lived. It is just as true for the clients in my criminal cases who ask me almost without exception whether the judge who is about to sentence them will know anything about their lives and who they are as human beings, or whether the judge will only know about the conduct that led to their conviction. Those experiences, the people, the clients that I have worked with over the years are the reason why I want to become a judge, because I know the impact that the judicial system has on people's lives, and because I would so greatly appreciate the opportunity to follow in the footsteps of the best judges I have known, dispense justice with the same fairness and compassion to the people who appear before me in my courtroom. That is why I submitted my application, and it's why I appear before you today seeking confirmation to the Superior Court. Thank you.
Let me start with Councillor.
Thank you, Madam Chairwoman. Well, that was a great, great introduction. One of the best I've seen here in 9 years. I come from a different perspective than some people in the room. I was a cop for 30 years. I've been a lawyer for 30 years. I was a law clerk at the Superior Court 30 years ago. And I really appreciate your public service. You're an outstanding candidate. I first heard of you last week when I was in Spain on a bus on a tour, and we're going to lunch. And I got an email from the governor's office, and I opened it up and I read your resume. And I sat down at lunch with 35 other people from the bus, and two ladies were sitting on the side of me, and I got a call from Lon Povich. And I said, "What's up, Lon?" He said, "Can you talk?" I said, "Yeah, we're waiting for lunch. I'm in Spain." He said, "Well, I want to talk to you about this guy." And I said, "Oh, let me tell you about him. Class valedictorian at Foxborough High School, Dartmouth College, Harvard, you name it." He's like, "Wow." He goes, "Yeah, he has my resume, but he's really smart." And when I hung up the phone, I was convinced that Lon thought you were the best thing ever. And the two people on the side of me said, "Hey, I just heard you mention Foxborough. I don't mean to be nosy, but like, what's up?" I said, "Well, there's a guy from Foxborough who got nominated to be a Superior Court judge. These two women happen to be former select people in Foxborough. It was Ginny and Lorraine. And they said, well, I don't know him personally, but I know his family. His family's outstanding. So here we are in Spain talking about you with two people from your hometown." And then I started asking about you further, and I asked my managing partner at Catch's Law Group, and he's a Foxborough guy, and he knew your whole family and has great respect for your mom and your dad, and just an outstanding family that you come from, great roots. I listened and I read some of the things. One of the things that stuck out was one of your chiefs said you temper justice with mercy, and you weren't draconian. And I know some people want to see people put away forever, but you have a soul, and I think you've got to make a superb judge. Not that I wasn't convinced already, but then when you and I spoke, you mentioned my hometown of Swansea, where your family was from, then the fact that your mother was Portuguese, you had me at I think we have one Portuguese judge out of 400, and although you don't have the Portuguese name, you're, half Portuguese, and I think you're going to be an outstanding judge, and I thank you for your service. I thank you for applying, and if your daughter figures out how to make my mind learn a different language, please let me know. I'd love to speak Portuguese or Spanish or something, but thank you so much. You have my vote next week.
Thank you.
I'm sorry, Councillor Iannella, your turn.
Thank you very much, Dr. Councillor. I don't have any questions for us. Unbelievable, isn't that? That was Harvard, schools. Is that the number? I know some schools it's number one. I still went to RL. The students vote for that. I'm just curious.
It was determined just mathematically, on grades. Yeah.
Yeah. But yeah, you've done great. You're going to be great addition to the Superior Court. I did also get a call from Lon Povich, speaks very highly of you. And when your name comes before us for next week, I'd be more than happy to support you.
Councillor Duff?
Thank you. Your witnesses made great presentations, by the way. Very good. So I've read that you've tried, I thought I read in here somewhere 24 to 30 cases. How many of those cases were in state court?
I have tried 4 cases to verdict and, well, actually, let me correct. Superior Court, 4 trials to conclusion. District Court, I rotated through the Middlesex DA's office in connection with a program that Hilton Barlow had back when I was an associate there. I probably tried a dozen or so cases in district court. Those were all bench trials, not jury trials. And they largely involved OUI, assault and battery, your classic district court type criminal case.
So basically, right. Okay. So you've tried in Massachusetts, so you've tried about 50 cases total?
Yes.
Am I right?
Yes.
And probably about 14 of those in state court.
Correct.
So half of your, so more than, about 55% of your experience is in federal court.
Give or take. Can't do the math in my head, but that sounds about right.
At it, that's pretty close. Okay, and you've got a great resume, and you're clearly bright, and we all knew Lon was gonna call because you're Dartmouth Harvard, and that was just like, as soon as I got off the phone, I'm like, I wonder how, I'm watching my clock, thinking how long this is gonna take. Which is great. I mean, he's a great guy. We know you're real smart. As I told you, and I think you thought I was being cheeky when I said it, it's obvious you can read and write. Which is not the case today with everybody, and it's not the case today with everybody who's a lawyer either. I had a very classic education, and so to me, it matters. And you can do that. And some of your writing, although there hasn't been a lot lately, is quite good. And you answered the question I asked you this time in your opening statement, why you want to be a judge. Because the answer you gave me when I spoke to me was not a good answer. That said, tell me again, why Superior Court? Why not federal court?
Well, the short answer is, I think the Superior Court is just it's a court of true general jurisdiction. The breadth of the matters that come before a Superior Court judge is far greater than is true in federal court. And I actually think it's, in terms of apologies to all the federal judges who might hear about this, but in terms of the relevance and the significance of the contribution that's made to real people in the real world, I don't think there's much comparison, which is not to give short shrift to the importance of the cases that are filed in federal court. Those are obviously very significant and very important to the people involved. But I just feel as if the Superior Court, because of the breadth of the cases that appear before it, is just a little bit closer to people in the community, to real.
More than district court, where most of your trial experience in Massachusetts has been. I mean, it did.
Breadth is
Down at. You've only had 4 cases in state Superior Court in Massachusetts.
4 trials, yes.
Yes.
Yes. Many more cases, but only 4.
That's small cases. The whole idea is not to go to trial, right?
Yes.
And people don't realize that, but the whole game is don't go to trial.
The whole game is to achieve the best resolution you can for your client. And often that involves avoiding trial, yes.
Correct. Okay, so, I kind of get what you're saying, but if you talk to anyone sitting there that's applying for district court, everyone will tell you district court's a court of the people. And you just said it's real Superior Court.
I guess I'm referring to the breadth of the cases and my own experience, right? So when I think about the Superior Court cases versus the district court cases that I've handled, in Superior Court, I have handled employment cases, both sides, for the plaintiff and the defendant. I've handled personal injury cases also for both sides. Obviously, no shortage of business disputes also in Superior Court. And, I'm not a district court practitioner, and so I can't really speak from personal knowledge. But my sense of the Superior Court is one where it just really, truly a court of general jurisdiction, which is why.
So you still have more trial experience. You don't have much trial experience in the Superior Court
Correct.
in Massachusetts. And so you want to sit as a judge overseeing trials where you have very little experience. It's
That I appreciate where you're coming from, and so I'll say yes.
good. That's the right answer. Because it's true. So what would you say has been a pinnacle life experience for you that informs how you will sit as a Superior Court judge?
Well, I think I'll answer that in two ways. I think my upbringing has been pivotal to me. I did not college expecting to become a lawyer, even on my radar screen. No lawyers in my family. I think my parents had two friends who were lawyers. So I went off to school thinking I was going to become an engineer. And that didn't pan out so well after my first year. And so I switched and I got a degree in economics. And, as I was headed towards graduation, trying to decide what I would do next, tons of investment banking firms were coming to campus and interviewing. Didn't really appeal to me. Spoke with the two friends my parents knew, but I'm deviating from your question. My upbringing and the values it instilled in me and the people that I dealt with just were huge in making me who I am today. And the other thing that I'll mention, and I'm going to guard the privacy of the person I'm thinking about, but I have a close family member who has serious mental health challenges. And that has been obviously hugely impactful on me and my youth. But what it also has done, and anyone else in this room who has a close family member who has challenges, what you find is people come up to you and share. And they share what's going on in their own family. And you get a window into a world that you otherwise wouldn't even know existed. And that, to me, the comfort that it brings, the community, if you will, of other people who, every family grapples with serious issues, right? And challenging issues. But having a family member with those challenges and meeting all these a lot of my peers in high school that I might not ever have connected with, whose parents spoke with, my parents and knew what was going on, would come up to me and share. And that also has, it sort of broadened my perspective on life. It has deepened my, sort of my empathy for other people. That's been a huge influence on me as well.
That's terrific. And I think that's a great, sincere answer. Sometimes I ask that question and people actually give me some other answer and that don't answer the question. And I agree with you. When there's certain issues that I've spoken about in this room, and a lot of times I just say things, I get sick of hearing myself say it, but I say it aloud over and over and over again because that's how we learn, and that's how we collectively learn, and that's how I've watched things change in the last 11 years of being here, is by speaking, as one might say, truth to power, speaking things. It's always been remarkable to me, people who've been in the audience who've come up to me later, emailed me, or called me and said thank you. That is probably the one thing about this job that has shocked me more than anything. And it's very rewarding because you're just really doing it because it's my job, right? I don't just represent one type of person, I represent everyone. That speaks very much to what Ms. McCurdy was speaking about with you earlier. But the ability to listen, but the approach, you're obviously approachable, and I think that's a wonderful thing. I had one other question, and honestly, it's gone out of my head, so it can't be that important. to ask you right now. Oh, no, I know what it is. And this is, I think, a very important question, and I want the chief, she's heard me ask this before. You know, we recently, within the last, I'm gonna say 3 weeks, had a judge assassinated, Virginia or someplace, because the fellow in his court didn't like the ruling. And so he decides he knows better and he goes and kills the man. This is happening more and more. And it's very, very, very disturbing to me. You know, you go into separation of powers and all of that sort of thing. But the very fact that we've become so undone and uncivil as a society that we think it's okay, and it happened in my district, where there was a judge in Superior Court who made a ruling, made a decision, which frankly was quite shocking considering his background of being a sort of law and order strict guy. But he made a ruling that was quite out of character for him, and people went berserk. People in this room went berserk, calling for his impeachment, protesting at his home, threatening him, threatening his family, threatening the workers of that court. I spent an entire day in Salem Superior Court meeting with every single member of that courthouse in Superior Court, just to listen to them. That had been rained upon them by people that think it's okay to threaten people because they don't like the decision. And, you know, I don't like your decision, so off with your head. You should be impeached. We don't want you anymore. I find that so outrageous. And I have found personally with this US Supreme Court, which I don't agree with almost anything they do, I've had to really check myself of like, who am I, right? If I don't think it's okay to protest at a local state judge's house, is it okay to protest at Brett Kavanaugh's house? You know, you can't have it both ways. We are who we are, or we're not anything. And so the question I ask a lot of people, and particularly I think in your court, do you have a good support system of friends and family? And I sometimes even call it a spiritual support system. And I don't mean by that religion, although if that's your thing, that's fine. But the threats against that could possibly be against you and against your family, you work in the public sector as well. People will know who you're married to when people disagree with it. Have you thought about this?
Yes. And, you know, it's something that if you've been a federal prosecutor or any kind of prosecutor, it's something about which you're aware. Because just as some judges have been assassinated, so have prosecutors.
Absolutely, they have.
And so when you become a prosecutor, there are certain recommendations that are made to you and that you try to follow, right, to ensure your safety. When I was chief of ECU, I had an assistant in my unit who was the target of a hit or an attempted hit, which was caught during the plotting phase. But you know, the resources that were marshaled to try to ensure the safety of that prosecutor and that prosecutor's family is something that, you know, I was directly involved in. So I'm not naive about the unfortunate risks that might come with becoming a judge. With respect to your question about a support network, my family, really my support network. And with respect to the pressures that can be brought to bear on a judge, I go through life, and my family's heard me say this, and at least one of my children has started echoing it because she's absorbed the lesson. But what I say to her, and I say this to myself, if I'm starting a really stressful trial or coming here, and honestly today, and I'm a little bit nervous, I say two things to myself. No matter the outcome, your family loves you, and do your best. As long as you can look yourself in the mirror at the end and say, I know I did my best. It might not have been good enough. I might not have achieved the outcome that I wanted, but as long as I can say, I did my best and my family loves me no matter what, that can get you through a lot.
It can, and I agree with you, and I think that's wonderful, and I think it's great that you've imparted that wisdom to your child. But I do think it's important to have the conversations with them about safety plans and how dangerous this can be. I really do, and I hate that I have to have this conversation. But, you know, just a couple of weeks ago, and I don't know, I could be running out of time. Just a couple of weeks ago, Howie Carr did an article on the front, I was probably on the front page of the Herald, ripping a guy, frankly, who I didn't vote for procedural reasons, because I believe in rules. You know, and the things that he said about this man were just grossly untrue. About the judiciary, that you don't do anything. Our judges don't work. They're a bunch of hacks. They just collect money. I find that not just inflammatory, I find it incredibly dangerous. I find him an incredibly dangerous man. With a huge, huge platform. And so I say it to the chief and to you and to your family and friends, take it very seriously. We live in a society where we are really hanging on by a right now of civility. And I think those who are sent to the bench and work in the courts, like your colleagues, need to be very, very mindful of this and vigilant. And it's not, you know, I was just in Devaney for a couple of days. They're in shock. Everyone up there is in shock. It would never happen here. It happens everywhere. And so I hate to leave with such a thought, but I can't emphasize enough. When I saw that assassination on the news, that brought me back to Salem. That brought me back to my Superior Court judge and the threats that he was given in his family and people that protested at his house and said he should be impeached because they didn't like his decision. I find that outrageous. So that's it. Thank you.
Councillor Kennedy?
I just have a couple of comments, because we spoke quite a bit on the phone, answered most of my questions on phone calls. One of the things that always concerns me is when people come to the federal system and to the state system, and we talked about that a little bit on the phone. You know, some people make a great transition, like the Chief Justice or Judge Lang, who wrote a letter of recommendation for you, and have done a great job making that transition. I've been in both the Superior Court and District Courts for 40 years. Not everybody can make that transition as well as they have. And you cannot run the state courts like you run the federal courts. They're very different animals, especially Superior Court. How are you going to make that transition? Because your practice has primarily been in the federal system. You agree with that, right?
I do. It's been about 65-35, I think I put.
Well, but 65-35, but we're talking about 4 trials. How many of those trials were jury trials?
All of those were.
Okay,
So
how many firms?
no criminal trials in Superior Court.
Okay.
So it's a very fair question, Councillor, and
Which is what I, by the way, which is what I care about the most, because people's liberty is at stake.
so I think first, I'm very much aware of the differences between Superior Court in the Commonwealth and Federal Court. Very much aware, both the nature of the cases, the resources available, both to the judges and litigants, very different places. The other thing that I can say, which is a bit more specific and personal, is at Clements and Pineault, at our high water mark, we had 4 attorneys. Generally 3. We started with 2 and we finished with 1. That would be me when I closed the firm down. And as a small firm, tiny firm practitioner, really, even if I was litigating in federal court, resources were an issue, particularly representing indigent clients. And so I know what it's like to be resource constrained, and what my abilities were and were not. I was on trial once for 10 weeks in federal court by myself. No associates, nobody. It was just me, myself, and I, and a massively complicated.
That's most of them.
Yeah, no, I know. But I guess I'm sharing that with you to try to convince you. I know what that's like. I have been there. I have had judges impose extraordinary briefing obligations on me when I'm saying to myself, it's me, myself, and I, and I'm on trial in this other case. So I appreciate that. I've lived it, I've experienced it, and I will be very cognizant and aware and respectful of it.
That said, and I say this respectfully to Judge Lang as well as the Chief Justice, my recollection of their background was they actually had less experience in state court than me. They've made a great transition, you know? But in my 40 years, it hasn't always been the case. It's created a problem for practitioners like myself. And I'm gonna wrap up in 1 second because I actually have a judge that's looking, a court that's looking to talk to me about something, so I have to step out and make some phone calls. Judges can get a little ornery sometimes. I've noticed that in the last 40 years too. But my concern is on the criminal side. It does not sound like you've done a lot of criminal work. Your private practice has primarily been, well, I know you did some white collar stuff, but now you're gonna be in Superior Court. Murders, rapes, armed robberies, drug cases, gun cases, and you've never handled any of those, right?
Correct.
Okay, but that you're gonna be doing a lot of that. What have you done to get ready for that?
I read extensively, but that's reading, right? That's not. And you're absolutely right. So what my criminal experience has taught me is I'm very familiar with the criminal rules, the constitutional issues. I'm not going to say what's a motion to suppress. You know, I've done that. I've participated in countless sentencing, but always white collar. So you're exactly right on that. The best I can do is tell you that I will dig in. I will read, I will listen, I will confer with my colleagues. There are a number of judges on the Superior Court that I know because our paths have intersected in the past. And what's truly been remarkable to me is the number who have reached out to me on learning of my nomination, invited me to their courthouses, offered me their thumb drives with their research. It's truly been an outpouring and so excited me about the collegial nature of the bench. And that's just in the past week, right? So I will have a learning curve to climb. I absolutely will have a learning curve to climb.
I think you'll probably spend the next 3 or 4 years in a civil session anyway, but that seems to be what happens. But the Chief Justice will be deciding that. I think you're a great candidate in terms of the breadth of experience that you have. It's much broader than it. While it's limited in terms of Superior Court, it's pretty broad overall. And a lot of the questions I had, which that you know went in a lot more depth than I'm going into today, you answered extremely well on the phone. I was very impressed with you. I'll be voting for you next week.
Thank you.
Councillor?
Thank you, Councillor. Good morning. Barely. You had great witnesses this morning, and we were able to have a brief conversation heading into this hearing. I'm just going to ask you about a couple of things that haven't come up yet today at the hearing. The first is something that I think you had a chance to discuss with one of the other counselors, but way back in the 80s in law school, you wrote in the Harvard Law Review about prosecutorial charging decisions and how racial bias potentially does or does not play a role or had played a role at that time. So I don't expect you to remember the content of that article, but I'm curious, over time, as an observer of the system and as a potential Superior Court justice, what did you take away from that experience of writing that article? And how have you observed this issue over the years? What's your approach to it on the bench?
So you're right. There was an edition of the Law Review when I was on it. That was the student contribution to that piece was devoted exclusively to race in the criminal justice system. And I believe there were 4 of us who contributed different sections to that piece. My section was race in the prosecutor's charging decision. That was the longer of 2 sub-pieces I wrote as part of that edition, that version of the journal. I don't remember how old I was, probably 22, with no background in law. not a lawyer. So did a lot of research, a lot of reading, but it was very academic and because I had no practical experience writing it. I did go back and reread it. And I have to say what struck me was reading that piece written in 1988 and then reading the Harvard Law School report that Chief Justice Gantz commissioned very recently. And what struck me was the parallels between what the data was showing, what the empirical studies were showing in the 1980s, and what much more recent empirical studies continue to show in the 2020s. And, you know, a lot of the same issues. The case law is a little bit more developed now than it was back then, but it's obviously an issue that has been present for a long, long time and remains present today. And one that I am very much aware of, both from what I learned back when I was in law school and the studies and the articles and the case law and everything that has come out since. So I don't know if you're asking, but I assume in there is a question as to whether or not that is something about which I'm aware and something about which I will pay attention and something about which I will consider argument.
How will it impact your jurisprudence?
I think in two ways. I think one of the most important, you know, everything's important, right? But an important aspect of my being a good judge would be an awareness of my own biases and the ability to constantly self-check myself continuously.
I'm curious your perspective because you've read the Harvard study, which is a few years old now, but nonetheless, one of the findings based on their data was that the charging phase, folks were more likely to end up in superior than district if they were Black or Latino, and that exposed them to higher sentences. And then because of that, in the hands of the superior court, being exposed to higher sentences, they get higher sentences. And so we see disparities start to play out in the sentencing, and it's happening. The sentencing disparities happens in superior court, but of course, that doesn't mean that doesn't mean that the onus is on the superior courts exclusively. There was a trail that got us there. And so since you know that and you're well read, and is there anything then to do about it, or is it just simply to be aware of it? Well, your point is well taken, and it's important that it's a part of the discussion, and it is very much, even in my brief time on the council, become a part of the discussion, which I happen to be bringing up today, but my colleagues do frequently as well. But what is there to do about it?
I think as a judge in my own courtroom, considering an individual case that comes before me, so pick a criminal case, right? Because that's what we're talking about.
Sure, a gun charge.
The first time I'm going to see that case is at arraignment. And there are decisions that get triggered from the very first day that case is in front of me all the way through to the end. So there may be an issue about pretrial detention, bail. That comes before me in connection with a particular case. There may be pretrial discovery motions that are filed and rulings sought during the course of trial, jury selection, jury instructions, sentencing. And each of those
things you account for race in each one of those decisions, or why are you racist?
As I encounter each of those decisions, as I hear evidence on those, as I read the briefs, as I make decisions, always being aware of the possibility that bias has infiltrated the process is important, right? So
is there room for a judge to do anything about it though? Because again, we're back to we acknowledge it, which is important. Again, I don't discount that. And it's not a trick question. I'm just curious, philosophically, do you think there's anything for a judge to do? Is the judge's hands tied?
There is. I think what a judge can do is to do that judge's level best to try to make sure that racial bias is not affecting the decision-making at any of those stages that I was just outlining for you. That's what the judge can try to do personally.
Okay.
But then as the judge as sort of dispenser of justice, as ruler in that courtroom, can be vigilant and aware at each stage of the process. So jury selection, peremptory challenges. If there's an objection raised that one party or the other has systematically exercised their peremptory challenges to strike every prospective black or brown juror from the veneer, then that's something a judge can address right then and there. If it rolls forward to sentencing and a judge is considering the various factors set forth in the advisory sentencing guidelines, the best practices for the Superior Court, that judge can be highly attuned to whether or not there are any biases that have affected the prosecutor's recommendation.
So let's jump on there. Let's jump on the sentencing guidelines. Because in your application, when asked to categorize your views on how to exercise discretion, you basically cited the sentencing guidelines as a model for that, right? And so you happen to just be discussing the potential impact of racial bias. But of course, there's several mitigating factors in the sentencing guidelines, including that the defendant's criminal history category overstates the seriousness of the defendant's crime. Just as an example, something that could potentially, in some cases, overlap with racial bias in their community. It could overlap with a number of challenges that they may have faced. Maybe it overlaps with nothing. But so when you're looking at the sentencing guidelines, you wrote about them as reflecting available social science research and empirical data relating to recidivism reduction studies and programs. We all want to reduce recidivism. Is reducing recidivism part of your judicial philosophy if you become a judge? Is you're crafting sentences and you have the crime, you have the conviction. Do you also have the likelihood of recidivism in your calculus?
Yes.
And how can you determine that? How would you go about thinking about the likelihood of recidivism and how a sentence could be crafted to ameliorate it?
Well, I think the first thing would be to gather as much relevant facts as can be gathered. So those could come to a judge through request for sentencing memos from counsel. They could come through a request by the judge to a report. They could come, if warranted, and I'm not saying this would happen all the time, through a decision to conduct an evidentiary hearing, if additional evidence is deemed.
The sentencing guidelines kind of suggest that. They leave an opening for that.
Yes.
Yeah.
I mean, they're quite
It's not as if it's a far-fetched idea to.
No, not at all. I'm just acknowledging that not every case is going to warrant an evidentiary hearing and sentencing, right? So gather all of the facts. And then as part of that, and as part of determining what an appropriate sentence would be, both the best practices that the Superior Court has issued and also the advisory sentencing guidelines set forth the various purposes of sentencing and set forth the various considerations that judges are recommended to consider. And
so let's think about the purposes then. Let's think about the rehabilitative piece. Are folks getting rehabilitated in our correctional facilities?
To be honest, I don't have firsthand knowledge.
When's the last time you visited a correctional institution?
I have not visited a state correctional institution.
If you were to be approved by this council, would you visit a correctional institution sometime soon?
I think I would like to. I think I would like to, and I would have to discuss
the possibility of that.
Yes.
I hope you pursue that. That would be good. I can tell you that there's a lot of good people in our corrections, but rehabilitation doesn't always happen because of resources, because of conditions, whatever. I mean, if rehabilitation isn't happening and that's a primary goal, then why would you send someone to jail? It's rhetorical. I believe that jails serve a function.
Yes. Well, there are multiple purposes to sentencing, right? And rehabilitation is one of them. But there are others, such as deterrence, both specific and general, punishment, protection of the public from future offenses. So rehabilitation is one. But to answer your question, irrespective of what rehabilitation programs are or are not available, that would not be the sole dispositive determination as to whether or not a period of incarceration was warranted.
We discussed briefly, and it came up a little bit today, just the issues of mental health that our communities face, and it trickles into our courts. I mean, folks acting impulsively in accordance with underlying mental health conditions, there's no deterrence by incarcerating them, right?
I would agree with that. Well, much less deterrence if they're not capable of sort of controlling that aspect of their personality. Yes.
I appreciate your thoughtfulness. As I said, you're clearly intellectual, you're measured, you have that judicial temperament. You're very well prepared. So, yeah, I appreciate our conversation. I appreciate your time this morning. Thank you, Councillor.
Thank you. Councillor.
Thank you. Hello, good afternoon now. I want to start off by saying I appreciated you coming out to North Adams. We had a lengthy and wide-ranging discussion about your background and your beliefs and your values about things. And so I want to follow up on a few of the things we've discussed already, some of which have actually I appreciated Councillor Kennedy's questioning around your criminal experience. It mirrors my own questions, and we've talked about it briefly, but it remains, as much as I'm a reader, I'm a researcher, I value the information that can be gleaned through those means. I do believe education is the best, experience is the best educator for some of these things like trauma response, mental health disorders, and I appreciate you have a personal connection, but mental health, challenges show up in many, many ways. One experience I think is great in terms of sort of opening your mind to the arena, but it's there's not one description of what a mental health challenge is or looks like or presents or behaves. Same with trauma response. There's not one single way that trauma shows up in responses. And same with substance abuse, the communities that are affected by that. So having said that, I'm looking to hear from you more than information gathering through readings and colleagues, how you might, or if you have an intention around being more understanding of the challenges and how those challenges present amongst those communities, trauma, mental health.
Well, I'm following your question. And you've touched on this, there would be a diligent effort to continue educating myself. I mean, one of the things I often think of as a strength, sometimes maybe not so much, is I'm a very curious person. I enjoy learning about all manner of things. And I mean, I truly enjoy it. And it's important because it broadens your perspective on everything in life. So I would continue my efforts to educate myself. And those can take various forms. They can take the form of reading on my own. They can take the form of attending conferences. They can take the form of meeting with and talking with people who have more expertise in an area than I do. They can take the form of walking down the hall or picking up the phone and calling a colleague on the bench who has grappled with a case presenting precisely those issues, and I want to pick their brain. There are all different ways in which I, as a judge, if I'm confirmed, can seek to deepen and broaden and do so in a way that isn't academic, but that is grounded in the real world. That's kind of the best I can do. In terms of, although, I say I shouldn't even say that, right? Because it may not be the best that I can do. And maybe in the course of engaging in all those efforts, people will have suggestions about other things that I could do that might even be better and more helpful. And I'm open to hearing that and implementing those and following those recommendations as well. And you know, I pledge that I will do that.
Well, I think one of those things is, I was gonna ask you about, I don't feel the need as much, but going and visiting at least one, if not multiple, of our state prisons, the jails is or less, I guess, relevant for Superior Court. But that's an experiential approach, and one of many that come to mind in terms of how to expand your understanding for those challenges that are very prevalent in the kinds of cases that show up regularly in Superior Court. Also things like trainings, you know, the judge conferences where they may have trainings, that's I think a great way as well. I was just, yesterday I visited the land court to understand that court, and one of the judges was not present because he's, I want to say Alabama, but somewhere in the South, taking an anti-racism in the courtroom training. Like he was off doing that. So I think things like that, availing yourself of opportunities to expand your understanding of these, because it doesn't reflect in your resume that, you know, you've had much experience with these communities, and they are significant population in Superior Court. We talked a lot about bias when we were together, and I very much appreciate that your wife came up a lot, so it's nice to meet you. I heard a lot about you, and I appreciate that you have vibrant conversations at home about it. Having said that, during the course of our conversation, it was clear there was a bit of bias blindness in how you talked about some things. When we talked about your pet peeves, I'm not going to be explicit about what we discussed, but the example you gave had multiple layers of bias baked in to your answer, which I mentioned at the time, but just in terms of holding up a mirror as to the kind of work one can, and I think as a judge should do, in understanding one's own biases and working to affect change around them. I do appreciate the work you do at home, but I feel like there's implicit bias training, there's Harvard bias tests, there's sensitivity training, there's cultural competency training. There's so many other ways to really ensure that you're doing as much work around being aware of your own biases and doing that work to affect change around them. And I highly recommend them to you. I think your heart's in the right place, but I do feel like a more intentional diving in on that. You would be a better judge for it, I think.
I appreciate that suggestion. I do.
And I don't mean to insult you in any way, but
I don't take it as an insult. I really don't.
Having said that, I really don't have any further questions for you today, and I'll just again say I very much enjoyed our conversation and got a lot out of it, and a lot of appreciation for who you are and what you bring forward.
Thank you, Councillor. I want to thank you for all the time you afforded me. I really appreciate that. And now you're on the Hall of Fame waffle with Justice Island, Justice Bud, and so many others. But seriously, I really appreciated the time that you afforded me. Well, a lot of questions have been answered. And one of the questions, and Councillor DeLeo had asked you about it, that I was concerned about. I love that you have the writings. And it just amazed me that here we are 35 years later, and you wrote those two writings in 1988 about bias in the courts, and it's still existing. I go out into the prisons and I meet with people who have had life in prison without parole. One of these men wasn't even in the room when his friend killed someone. This is what I see. So how far have we got? How far have we got from your writings?
Far enough? I mean, to state the obvious.
It does exist, doesn't it?
Yes.
And I'm fighting it, but what can we do? What can we do to stop it? I mean, some of these judges, they should be charged for what they do. but I don't see it. And that bothers me, you know? There's so many injustices that I see, and that to me really stood out. Now, I talked about it and I was really, you took a case, a disability, took on two of the biggest movie theater companies in the country. And I identified with that. And I told you, well, I was on the Commission on Disability for 22 years. And you had this case where they renovated this theater. And they set aside people in wheelchairs and people with disabilities, physical disabilities, in the front row. Well, I told you, about 5 years ago, I went with a busload of people for a movie about the Armenian genocide. There were so many of us going in the theater that the only seat I had was the front. And it was like this through the whole thing. By the end of it, my neck was, it was awful. And this is what they delegated, people with disabilities. How unfair. Tell us about that case.
Well, for those of you who don't know the chronology, your traditional movie theater for years was a sloped floor. And then in the really the 1990s, you had some theaters rolling out these stadium style where you would, it's like in a football stadium, there'd be risers, tiered steps. And it gains several advantages. It elevates you more in front of you, so you're less likely to be visually obstructed by a 6'5" person's head when you're trying to watch the movie. So you had these stadium style theaters being constructed. And just because of the expense and the design considerations, they were putting the wheelchair seating areas. They'd have 2 or 3 rows on a flat floor right in front of the screen. That's where they put the wheelchair seating areas. And then behind those, they had the tiered seating. So I was working with some attorneys at the Civil Rights Division at Main Justice as we embarked on negotiations with the largest movie theater chains in the country to try to persuade them to revise their designs, and did not meet with a lot of success. Negotiated really for 2 years or so, and they tweaked the designs a little bit, but not sufficiently. So we ended up bringing what are called pattern and practice cases, which are nationwide in scope, filed typically where the company is headquartered. So I ended up filing on behalf of the United States pattern and practice cases in Boston against National Amusements, Showcase Cinemas, and also Quartz Cinemas as well. And Main Justice filed 3 other national actions against movie theater companies based elsewhere, and all the cases were proceeding in tandem. So, it's hard to convey the importance of accessibility issues unless you have spent a lot of time with people who grapple with those challenges every day. And so for them, the ability to go to a movie theater with their friends, excuse me for a sec, and sit with each other in a decent seat really matters. In touring some of these newly constructed theaters with a number of different advocates, almost all of them were in wheelchairs themselves, and having them explain to me, and then working with, we had a wonderful expert who was an architect who previously had designed movie theaters, and so he was the expert for me in my cases, in talking with him so he could translate into architectural principles, what I saw with my own eyes, and why I never would sit in the front seat if front row, if given the choice. We brought the case, or the cases, I should say. I recall two specific examples, and then I won't go on forever because it was a long-running case and it was very important to me, so I could talk about it for quite some time. But 2 specific examples. One was a young woman, and I mentioned this in my application, from Ohio, I believe, who I spoke with on the phone. And I was connected with her by a disability rights advocate out in the Midwest. And she told me that she had been in a serious car accident as a young adolescent, paralyzed from the waist down, in a wheelchair, really had a very difficult time for any adolescent. And fast forward 2 or 3 years, as she was nearing the end of her time in high school, a young man asked her out on a date, which was huge for her. Just huge. And he was all excited because they had just opened a brand new stadium style theater in the nearby town, and he was going to pick her up and take her there. And so they arrived and came in the entrance to their particular auditorium, and she immediately saw there's no way I can get up the steps because I'm in a wheelchair. And she felt horrible because everyone was excited about sitting on stadium style seats, and she couldn't do it. And she was embarrassed and she was humiliated. And she was further embarrassed and further humiliated when her date said, well, I'll just pick you up out of the chair and carry you up the risers. And she declined and urged him to go sit in a decent seat, and she would sit by herself in the front row. And, talking to her, she was crying on the phone, obviously very emotional for her. So that was one experience. And then, amazing to me, I was out in another part of the country going to tour another theater with an advocate in a wheelchair. And I was staying in a major chain hotel, and I can't remember which one it was. And I don't want to slander any of them by giving the wrong name. But it was a major hotel chain. And I was staying there, and I was meeting her in the dining room to have breakfast and talk before we together went to tour this theater. And the breakfast buffet was up 3 stairs, and which she spotted immediately. And it just amazed me that at that time, which was a good 15 years after the passage of the Americans with Disabilities Act, I could be in a newish seeming major hotel chain and have that situation confront her. And it's not the only one. I mean, we opened up the brand new federal courthouse in Boston. I mean, I'm digressing now, but I get worked up when I think about it. Brand new federal courthouse. I had the first trial in that building. Very first witness, very first trial in a wheelchair. And he couldn't get into the witness box because it was a 6-inch step up to get into that witness box. And it just amazed me that at that time in a courthouse in Boston, that impediment existed for somebody in a wheelchair. So the work that I did on accessibility cases mattered a lot to me. And so that's one of the cases that has had the most personal significance for me.
Out of all your experience, just those two, those writings about racial disparity and representing disabilities means so much, because you are a judge, you'll be a judge that understands Asperger or autism, and it's important because a lot of judges don't understand that, and they misunderstand that person before them. So I think that's very important. I like how you have been in all different positions, especially in your own office. So you had your own practice, you chose who you're going to represent, and to me, you had the responsibility of paying the rent and shoveling the snow and all that. So you have all of that experience when someone comes in before you. So I think that's important. And then you're aware that that person coming in with the lawyer, with their being charged by the lawyer, so you can arrange to have different people come at different times and all that. So that all means a lot. Now, out of all your positions, what do you think, can you think of one of them that gives you the most qualities to be on the bench? Is there one that comes to mind?
Well, they're all valuable to me in different ways for different reasons, but I think I had to pick one. I would say it's the times in which I represented individual defendants in pretty serious criminal cases. probably educated me in the broadest sense. And it just both with respect to the seriousness of those cases, the enormous importance and the profound consequences those cases had for those individual clients, the challenges that are confronted by people who don't have infinite resources to defend themselves when charged in a criminal case, the difficulty for me as a lawyer to provide the level of representation I thought the case warranted on really what was a shoestring budget. When you have an indigent client, the volume of the discovery produced by the government is measured in terabytes, and you have to try to, appeal to the court, petition the court for funds to get the software you need to be able to have a chance of reviewing that discovery material. All of those experiences, I think, informs me in a way that will be very helpful if I'm confirmed and take the bench.
And then you work as a criminal defense attorney. That brings a lot to the bench too. And what I like what you said here, you said that my clients have no choice but to place their faith in a system that they desperately hope and need to be fair. And that says it all, doesn't it, huh? But, and you even were involved in education, and you established, the education committee, the executive office of education. And that's so important. So what I saw when I met with you, and you gave me a lot of time, was your temperament. And that means a lot, your temperament. And when you talked about what are the four qualities of a judge, you said fairness. The first thing you said was fairness. And you can't ask better than that, fairness. And that's what I saw in you. But the other thing is, I don't vote for anyone if they don't have compassion. You have it. And your pro bono work, if you get a 40-year-old, they haven't got time for pro bono. And they don't have the life experience that you bring at your age and what you've done. And I can't thank the governor enough for, presenting you and for you to apply. And I'm seeing that in this new administration, and I couldn't be happier because we need qualified people. We don't need political friends. We need qualified people. And I'm so honored that that I could preside over you, because I want you people to know I had Wayland taken away from me. I had it like 12 years, and so for, I don't know, decades, I haven't had it. So all of a sudden, I lost this and lost that, but I got Wayland, and I said, wow. And I'm telling you, my 25 years, we've never had a nominee from Wayland. So you made Wayland proud, believe me. So I'm going to ask if there's anyone in opposition. And is there anyone here that wasn't on the list who would like to say a few words about this nominee? Feel free. Okay, I think that, you're the whole package. I can't imagine anyone coming before me that would have all the things. Before you go, though, I do want to ask you, you must like to write.
I do.
Yeah. And Superior Court, you need to write. And if you could tell us about your writings, because I'll tell you, I've been here 25 years, but we don't see a lot of white crime. And tell us about that. And where is it now? Was that resolved?
Are you talking about the writing?
Miss Carter?
Writing, that case is now over. So I think I submitted as a writing sample a post-trial motion for judgment notwithstanding, a judgment of acquittal, I think. So that case is over. So as I think I explained in my application, the trial judge granted the motion for judgment of acquittal. The government appealed, the First Circuit reversed. Ms. Carter has been sentenced. She has served her sentence. She is now back home, and the case is fully resolved.
How long were you involved with that?
I think it started in 2014. And I think it concluded in 2022, 8 years.
Well, I would tell you, your witnesses were wonderful. They know you personally, they know you professionally, and that means a lot to me, to all of us. And thank you, Council, for staying in respect to this nominee. It's an important day. And I just want to say, I don't have a poker face, and I've been smiling since I first read you. So I will be very pleased next Wednesday when the Lieutenant Governor sits here and holds the public assembly to put your name in nomination. And I'm very pleased. We're all pleased. So thank you. And thank you all for coming. Really appreciate it. And I'm going to adjourn.
As a judge, the last almost 10 years of that as the first justice of Suffolk. I retired because it's mandatory for us to retire at the
No way, there's no way.
old age of 70. I'm not going to ask anyone here how old you are, but the rightful age of 70, they make us retire. I want to tell you a little bit about Audrey. I did send you all a letter. I'm not going to go through everything in the letter. I'm just going to highlight the parts that I think brings us here today to watch this exceptional woman rise to the bench. If you were to all vote positive for her. I watched Audrey in the courtroom from 2008 to 2020, roughly about 12 years, in the criminal session. In Boston Juvenile Court, we've got one of the busiest juvenile sessions. We also have sessions in Dorchester, West Roxbury, and Chelsea. So she was a busy young woman. She appeared in all of our sessions. I saw her handle delinquent cases. She's also YO certified, which means she's handling the highest level of felony that juvenile courts have jurisdiction over, and we have the broadest sentencing powers. So an attorney who's representing youthful offenders has got to work within that interesting and combination sentences that juvenile judges can give. We can sentence a 14-year-old to state prison if they are found delinquent youthful offender. It is a heavy load to carry as a judge. She's going to be capable of making that tough decision. She's got the courage to do that. She also has the courage on the civil side to be able to either return children if the department has not proved their case, and by the department, I mean the Department of Children and Families, or she will be able to remove children and terminate parental rights of those parents that deserve to have them. I know from knowing Audrey Murillo that she will always, on the civil side, on those care and protections and the CRAs, have the best interest of the child at heart. That she will listen to the facts, she will calmly and respectfully listen to everyone in the courtroom. She will also calmly and deliberately make a decision. She also has, and this is important for you to hear, we need judges in the juvenile court of a certain maturity age, and I have made this my point with the JNC. You need the life experience to be able to go on the bench and be able to handle what happens, not only in the courtroom, but also handling the complex fact patterns that you'll have thrown at you. You also have to have that life experience, to have the patience to let a lot of stuff that's thrown at you in a courtroom by a client, by a defendant or their family, roll off your back. You don't want to spend your whole day just holding people in contempt. You won't get anything done. She will do all of that. And then the last point I want to bring up is she has the writing skills to be a juvenile court judge. A juvenile court judge, and I believe you were nominated for Worcester. Is it Worcester that she's going to do it? Does anyone know what?
So, yes.
Okay, so Worcester's got the highest caseload of care and protections in the state. Is that not right?
It's okay.
Okay. So she will be handling a lot of CMPs. A judge going on the bench in Boston, my new judges would come on and be immediately handle a caseload of 100 and then beginning to pick up about 20 to 25 new cases a month. When you write your findings on care and protections, I had this discussion with you the other night, it's 100+ pages for an easy one. So we need people with writing skills. She's got them. I've seen her motions to suppress. I've seen her oral arguments in court. She's going to be precise and deliberative. So I ask each of you, she's also the mother of 2 great kids. So that gives her some sense of patience, I think, and a husband who works very hard. So she's done a lot on her own. Her mother must be very proud of her today to have your daughter here on the cusp of becoming a judge. I would be so proud to have Audrey Murillo serve in the juvenile court. I ask all of you to vote in the positive for her candidacy. Thank you for your time.
Thank you, Judge. Always a pleasure to have you. Oh, I'm sorry, Councillor Jacobs has a question.
Sorry.
I just want to, thank you for sending the letter.
You're welcome,
As well
Councillor.
as I really appreciated your testimony just now. But there's I just want you to speak to a part of your letter that I didn't hear. I was busy looking for it, so I hope I didn't miss you saying it, but, and now I've lost it again. Okay, no, here it is. She understands the importance of intervention and diversion by both police and district attorneys in identifying juveniles who may benefit from rehabilitation in cases involving lesser offenses. Can you just speak a little?
Sure, so every county in Massachusetts now in the juvenile court, and we have a juvenile court in every single county since the statewide expansion, has a diversion program. And it is important that the judges remain involved in that program. So that means a child who deserves a break that comes into the court can be diverted out of the system. And a judge has to usually agree to that. The district attorney will ask for the diversion to be set up with certain rules and regulations. And so the practicality of a judge in setting those conditions is really important because you don't want to set conditions that set up a child to fail. You want to set reasonable, good conditions. She'll do that because I've seen her ask for reasonable and good conditions from representing juvenile offenders before me. Does that answer your question, Councillor? North Adams, right? You're a Westfield State girl.
There you go. Councillor Devaney.
Councillor Devaney, how are you?
They started before 1 and I left at 2 minutes of 1.
We actually started right at 1, but a few minutes later, that's fine.
Over the last.
No worries. You didn't miss a thing. You didn't miss a thing. You didn't miss a thing.
I just started when you walked in the door.
I'm so sorry.
What's your question, though?
My question is that, tell me what you have observed of this nominee in court. What qualifications, what her temperament, and what do you see that she brings to the court?
And I'll embarrass Audrey a little with this, but I have known her, I think, since her first couple of days in as a lawyer. She was a very young, inexperienced lawyer when I first met her. She had done some work in a firm, but she hadn't been in the pit yet, as I call the trial court. She matured extremely fast. She is articulate, so she doesn't waste my time on the bench by repeating herself too much. Because every lawyer, including myself, would repeat ourselves. And as a judge, I certainly repeated myself. Her quality of written work on her motions to suppress was superb, was absolutely superb. Her patience in the courtroom, a lot of times, and I'm sure those of you that practice know this, especially Councilor Kennedy, you go to court at 9 o'clock, your case is scheduled for 10, and you're lucky to get in by noontime. That means your client's mad at you.
I don't get out court.
Clients, parents are mad at you. And at that point, you've got to calm the waters before you walk in the courtroom. She does that superbly. And I think the written ability and the ability to articulate her position in a clear and meaningful way, and not to talk in legalese when she's talking to her clients, and she won't talk in legalese when she's in the courtroom as a judge. I know that for a fact. She's going to talk clear. Anyone in that courtroom is going to understand her decision, is going to understand her conditions, and is going to understand how she got there, reasoning-wise. Does that answer your question?
It's a tribute to the nominee to have you here. I was there before you retired. I didn't want you to retire.
That was the law, Marilyn. I would have broken.
Trying to change it, but no one's out there doing it. But thank you, and thank you for all you do.
Thank you. I was saying that you and Chris Iannella are the two councils remaining here, that I was lucky enough to get to vote for me twice. So I thank you again for that opportunity. Thank you.
Thank you, Judge. Next, we're going to hear from Professor Lila Umana. Did I say that right?
No, but
We're going to hear from the professor.
I prefer actually to stand if that's okay. So good afternoon. Good afternoon, everyone. My name is Professor Delia Umuna. I am a professor of law at Harvard Law School, where over the last 5 years or so, I have had the privilege of working with Audrey Murillo as a colleague. So 8 years ago or so, I was in Dorchester, minding my business, waiting for my case to be called. And then I saw Judge Kaplanis engaging with a young woman who was an attorney. This attorney was fierce. She was eloquent. She was indeed very brave as she skirted around the issue in front of the court. I looked at her with great interest and I thought, that's an impressive advocate. She Although the judge was pushing and prodding and pushing and prodding, Ms. Murillo remained calm. Ms. Murillo remained insistent, and above all, she remained very committed to the fact that she was there representing a client. Impressed with what I saw, never heard of her before, I walked up to her afterwards and I introduced myself. And I invited her, because we are always looking for great attorneys, I invited her to Harvard Law School's trial advocacy workshop, which is a 3-week intense workshop where you bring lawyers and judges from all over the country to visit Harvard Law School and train our students in mock trials. Ms. Murillo showed up at my invitation, but what she did know, and what I foisted upon her, was she had to do a demonstration. Now, she had never been to the workshop before, and usually I call upon seasoned folks to do that. And there she was, cross-examining an expert who had been doing it for 20 years. I was so impressed. Afterwards, many people came up to me and they said, "Who is that person? We've never seen her at TAW before." And I said, "She is now officially a member of the Badassery Club," which is, you know, a member of a club where people, especially women, who are fierce, who are smart, intelligent, where they belong. And so it shouldn't surprise anyone that when a position became open in my office to bring her on board as a clinical instructor, I jumped at that position, at that opportunity. I reached out to Audrey and I asked her, and there were so many qualified applicants, as you can imagine, who applied, and we selected her. Over the years, she has proven to be everything that we had hoped for. Smart, kind, fierce, intelligent, well-balanced. And you asked a question about her temperament. Patient, well-reasoning. It is, if you know what it's like to teach at Harvard Law School, I have students who think they know a lot more than I do. They don't. But you have to have a certain type of temperament to be able to engage all of those personalities. And Ms. Murillo, without question, excels at that. She has the absolute temperament to be a judge. I have watched her head up our amicus brief section, where she supervises some of our students write amicus briefs to the courts in Massachusetts. She is going to be missed. She's our resident expert on all matters juvenile. She's beloved. I'm going to miss her as a friend, because I do not know whose office I'm going to go into and rant about parenting and the joys of parenting. And Lola and Joaquin, through whom I live vicariously since my kids are much older than they are. But you have a wonderful mom and a brilliant attorney. And to her writing, I can only say it's exceptional. So I want to close with a few statements from evaluations from her students. I get to see them all since I am the big boss. But here is what some of her students say. She's great, very encouraging and easy to get along with. My supervisor was Audrey Murillo, and she was incredibly patient. Anytime I will have questions, I could email and text her, and her responses were always prompt. She always gave feedback on motions and oral arguments, which allowed me to grow in my advocacy. Fantastic communicator. Audrey is very responsive and does not always mind me when I call a panicked after-hour communications from students. Usually is available by email and text. Audrey is open to more than one meeting per week. She values independence, but not arrogance. And I thought those were telling. And finally, Audrey Murillo is incredible. She strikes the perfect balance between always being there for support and to bounce off ideas while also allowing a student a lot of independence and personal responsibility over a case. So as I said, Ms. Murillo will be missed. As far as I'm concerned, she embodies all of the characteristics of a judge: excellent temperament, high level of intelligence, impeccable integrity, tireless work ethic, and she's a consummate professional. She's not motivated by any desire for fame or fortune. Rather, she's motivated by a sincere desire to be of service to the citizens of the Commonwealth. Without any reservation, I urge you, I encourage you to cast your vote, because our loss is really going to be a gain to the Commonwealth of Massachusetts. Thank you. Thank you.
Kennedy.
Glad I never had a case against you.
I don't want to brag, but I want to say I got into Harvard exactly 3 times. Once to bring my daughter to orientation for the Chan School, and twice more when Judge Pineault was presiding in the juvenile court in Bristol County, and I spoke at one of my daughter's classes. And it was one of the best experiences of my life, because we got to speak to wicked smart people around the globe. Probably never met a police chief or a judge before. And when they got to hear from us, like practically like how we did things and how we have evolved over the last 30, 40 years, and how the court treats people and the wonderful work that you people do. So thank you for inviting us to Harvard. Thank you for what you do, and thank you for making a huge difference in the lives of so many juveniles. I think you guys are like the most important court when it comes down to brass tacks, because you shape the lives of children until they're adults, and nothing could be more important. So thank you.
Thank you. Thank you.
Last, we're going to hear from Steve DiFilippo, the owner of Davio's Restaurant. Welcome, sir.
Thank you for having me. I have to say, I've never followed a judge or a Harvard law professor. So, you know, we're not going to share grades or anything. Okay? Wow. I'm here because I've known Audrey for over 30 years, right? At least. She started at Davio's back, you know, in the early 90s as a server, and she was, this woman has such empathy for people. It's, you know, because she went to college, she would come back for the summers, and then when she graduated, she became one of our managers, and then she went and worked in the office. So she was always the person that everyone would go to. Like they didn't want to talk to me personally. They would go to Audrey, right? And Audrey would call me, Steve, you need to come talk. You know, she was always like the middle person for me back in those days. And it's kind of ironic that we're sitting here and you're going to be a judge, because you've kind of been a judge forever, you know? And, you know, I just think that, you know, to have someone like her who, when you really think about it and you look at her life and you look at how she started, you know, in the restaurant business, and then went on, graduated from UMass, obviously went to law school here in Boston, married Rodney, who is from Costa Rica, who started as a dishwasher at Davio's. Now he's our vice president and corporate chef for all 11 Davio's. They have 2 kids. They live in Milton. It's the American dream right here. It's just the American dream is still available in our country. And, you know, her mother's sitting right here. She came from Cambridge, Massachusetts. We're all from Boston here. I mean, it's just an incredible day, you know, and I'm just blessed to be asked to come here and talk about her, because we need people like this on the bench. You know, we need people like this who care, have empathy, who love people, who love kids. You know, when she came out of college, law school, what did she do? She went and helped immigrants become legal. She didn't go and work for some high-powered law firm. Not that there's anything wrong with that. That's great. Go work for a law firm. But she wanted to help people, you know. And here she is now, many years later, and she wants to be a judge, you know. And I can't believe you're going to be 50 in January, right?
Thank you for reminding me.
I'm a lot older than that, so I wish I was 50. But I think, you know, I just hope that you vote for her, because I think we need her. And I just want to thank you for having me today. And let's get going. Let's vote.
No. Councillor Kennedy.
Popovers? No, I just want to say, Steve, obviously you and I have been friends for a very long time. And one of the things that's always impressed me about your business, it's not from the top down, it's from the bottom up. Your employees are incredibly loyal to you, and I noticed that it's not just a restaurant, an employee employer relationship. It's a family there. And I've known a lot of your employees over the years. And I know she's part of your family in that respect. And obviously, your being here means a lot.
Yeah, well, thank you, thank you.
Councillor Duff.
Just want to say thank you for having gluten-free food at your.
Thanks. We're hearing about Audrey today. I thank you. Yeah, no, can I tell you how it started?
It's always about.
I'm gonna tell you a quick story. My daughter, Ella's 25. When she was 10, she got Lyme disease, like 15 years ago. And we went to the doctor, and the doctor said she's got to get gluten out of her diet. Yeah, I wasn't even sure what gluten was, at the time. I'm a chef, but I'm joking. And we did. And so then she came to Davio's, like, I don't know, a few weeks later, and we had like one thing. Rodney, I can tell you, we really were. I was like, guys, we need to come up. We need to change, and that's kind of what all started. Now we have probably the most gluten-free menu in the country. Well, thank you.
Councillor Iannella.
No questions. I've known Steve for, it's great to see you here today. Your remarks mean a great deal to me, and again, it's always a pleasure to see you.
Well, thank you. Thanks for having me. And this is really important. This is like probably the most important thing today.
I give you credit. We've never met before. I have been to your restaurants. They've been outstanding. The wine is really good. And congratulations for hiring well. The most successful people I know are those that surround themselves with good people in all aspects of life. And congratulations for hiring well.
Thank you. Thanks.
Thanks for coming.
Thank you. We did start early, just so you know. They started early.
All right, next we're going to hear from anyone else in favor.
Say that to you.
Steve, you're dismissed. Anyone else in favor of the nominee? Anyone else in favor? Anyone opposed to the nominee? Want to sit down again, Steve? Oh. You're dismissed. Thank you. So next we're gonna hear from the nominee. It's your floor.
Thank you. Good morning, Mr. Chairman and members of the Governor's Council. I am humbled to be in front of you today as a nominee for Associate Justice of the Juvenile Court. I'm grateful to all of you for your time this week, over the phone, in person, and I'm grateful for the robust conversations that we've had. I first want to thank my witnesses, Professor Delia Muna, the Honorable Terry Craven, and Steve DePalo. Their kind words mean more to me than they will ever know. I know they all had to clear their very busy schedules, and I'm so appreciative. I want to thank Governor Healy and Lieutenant Governor Driscoll for the nomination and the enormous trust that they've placed in me in nominating me to serve in the court that protects the safety of Massachusetts' most vulnerable children. I also want to thank the governor's legal team, Paige Scott Reed and Derek Kesselheim, for their support and encouragement in this process, and Valerie McCarthy for all of her help. I sit before you humbled by finding myself in this chamber. My journey here has been shaped in part by some childhood challenges. At 4 years old, my parents divorced, leaving me and my 2-year-old brother in the care of our hardworking mother during the week and on weekends with our dad. Until I was about 10 years old, we lived paycheck to paycheck in a rent-controlled apartment in Cambridge, Massachusetts. We lived there until the apartment was converted into condominiums, and we were forced to move, exacerbating financial strain. Despite working as hard as she could, my mother could not afford the rent, and we were frequently deprived of basic necessities. We were left alone probably more than we should have been, which placed some strain on our family. Despite being poor with a capital P, my mother put on her high heels each morning to walk to the T to go to her full-time job. She did not believe in wearing sneakers with skirts. At the age of 13, I got my first job and learned how to work hard. I've worked hard ever since. I am grateful to my mother. She instilled in me the ethos of perseverance when life throws you a curveball. And though she was poor, she always made time to be charitable, and for my entire life has volunteered her time to those less fortunate than her. I'm grateful to my father for his brilliant sense of humor. He taught us how to cope with hardship with humor. And I'd like to think I also have a sense of humor that I got from him. I will never forget where I came from and do not take for granted any of the opportunities I've been so fortunate to have with the help of caring adults along the way, one of whom is in the room, Marie Manduca. Let's see, where am I? As you've heard, I worked at Davio's restaurant after getting my undergraduate degree. It was until it was time to pursue my dream of going to law school. I did so with Steve's blessing and encouragement, remained a constant in my life. It was at Davio's that I met Rodney Murillo, my husband and the most considerate person I know. And Rodney and I could not be more proud of our beautiful children, Joaquin and Lola Murillo. We are those parents who remind our kids daily ad nauseum about how lucky they are and how tough we had it. As for my 17-year legal career, I'm fortunate to have spent the majority of it in the juvenile court. I knew I wanted to work with children since law school. I was drawn to the discipline, believing and hoping I could make an impact. I understood the fragility of childhood and the pivotal role adults played in my life, and I wanted to be one of those adults. For over a decade, I practiced delinquency and youthful defender defense, eventually becoming the supervisor for the private juvenile bar in Suffolk County. In that role, I mentored and evaluated attorneys practicing in the juvenile court and liaised with court staff to address their concerns and ensure the availability of attorneys when needed. Presently at law school, I oversee third-year law students for their forays into the juvenile and adult court. With both the students and attorneys whom I mentor, I do not always have all the answers, nor do I pretend to. But I have the aptitude, research skills, and legal support network to draw from to find the answers, a practice I would continue if confirmed. If confirmed as a juvenile court associate justice, I will continue to strive to make an impact on children's lives. I will seek to protect them from abuse and neglect and work to rehabilitate young people so that the public is safer for it. Thank you for your time. I ask for your confirmation, and I'm happy to answer any questions you have.
Well, thank you. That was a great summation of very difficult life and how you made it. And I want to let you know, I interviewed both your children earlier, and they said they would call you around at home, and they think I should vote for you. So you've done a good job.
Very much.
Councillor Devaney.
Councillor, could the nominee introduce all these great people?
She did. She did. Yeah.
Must have dozed off then, okay. Congratulations. Please don't laugh, Councillor Duff.
Go ahead, please.
And anyway, I really appreciate the time that you took coming out to see me. I was impressed with your background and how you've come. And I think that, to me, when someone comes before you, you can identify with them, you know, because from your background. So tell me, how did you decide to go into juvenile law? What was the?
Yeah, I think I was, you know, if I were really to get analytical, I think it's probably because of my childhood. I felt compelled to work with young people. I had these adults in my life that made differences in my life, and I thought I could use my experiences to make an impact on young people. And so 2 years after becoming an attorney, I began working in the court, and I've stayed there ever since.
Yeah, I was really interested in your the case that you. It was a motion to suppress evidence, and it was obtained without with search and seizure without. What did you say rather than me talk about?
I think that my writing sample that I provided was a motion to suppress. It was a memorandum for a motion to suppress. It was an interesting case where the person that called 911 described perfectly in detail the person that reported my client with the gun, and they described what he was wearing, what his backpack looked like, and the police arrived on the scene and they frisked my client. And the point I made with the help of the case law to the court was, I could describe Councillor Kennedy's jacket and tie perfectly and say he just left the state house and he has a gun. But is that enough for the police to frisk him without a warrant? And so that was the point I made to the.
It's enough, again, it's enough.
The juvenile court is really overworked, don't have enough attorneys, don't have enough representation for people. How do you feel about increasing the age, this juvenile court?
So first of all, that wouldn't be my job, but I can see both sides. It's the job of the legislature, as you know, and there is pending legislation presently to increase the age to 19. What I can say is, and what's more important to me, and not more important than the brain science although that's important, is the preservation of records. So in that sense, I'm in favor of raising the age. I'm aware that the court is pretty overwhelmed right now, and I know that resources would be an issue, and that's why I would I would defer to the legislature if they decide to do so.
Now, with your experience, what kind of changes would you like to see in the juvenile court?
Yeah, let's see here. Thank you for that question. So what I can say, since practicing, there have been a lot of changes for the better. And I think that the more the judges and the attorneys have become more aware of the data, of the science, like I mentioned, of the benefits of diversion. Since 2018, we've had statutory diversion as well. And so I think that the court and its level of consciousness around children has been raised quite a bit since I've started practicing. Areas where it could be improved, I think it's, there's often a strain on services. And again, I've seen services that you can send kids to through diversion programs or through probation, connecting a young person with services. I know in Western Mass, there aren't as many nonprofit organizations as there are here in Boston, and I'd like to see more resources to divert kids away from the court, or to send the kids to that come before the court.
Well, as when we met, I told you that for me, the greatest experience that I ever had in my life, I volunteered for a year with juveniles on probation. And I have to say, being married, having 4 children, I lived a different life, and you have a different expectation of thoughts about who are these juveniles on probation. And that was the best thing that I ever did, because I found out the other side. Found out a 15-year-old, and I would meet with them alone, take them for breakfast or lunch or whatever, and it took a long time to trust. So I can imagine it was the same with you. And when I heard the stories, they were heartbreaking. 15-year-old girl, mother's a prostitute, doesn't know the father, and she locks her in a room while she goes out. That's the thing. I mean, I learned a lot from that. But, I don't go with a book that's saying that the brain isn't developed till it's 25. My husband was 21. Okay, I had my 4 children by the time I was 25, and my brain is intact. I wanted those children. So I really think sometimes we go by book learning instead of life experience. And so, but what I'm upset now is, and you see it, there's an increase in juveniles in criminal activities. Now, is it because of drugs, or what would you say is increasing this?
I think that I think overall juvenile crime is down, and that's been a trend. I think that cases that make the news or might be more sensational, might be the result of, it might be leftover ramifications from the pandemic. Not being in school, not having the structure, not having a lot of these nonprofits that I was mentioning closed, and kids have been really clinging to them for structure, for activities to do after school, and they're coming back slowly but surely. But I think it might be a byproduct of COVID.
So what other things can we do for juveniles? What would you like to say?
I envision a world where there's more avenues for diverting kids from the court system, so they never come into the court system. I think that contact with the court system statistically is shown to increase contact with the court system. So getting to the kids that need the assistance before a civil case is filed or before a delinquency case is filed, I think would help with the court overall.
And you've seen so many. What was the most rewarding outcome representing a juvenile?
There's one case that I think we spoke about when we met, which was lovely, and meeting you, not my case. There's one case that sticks out in my mind because I represented a 13-year-old young boy, and he was accused of armed robbery, and the victim in the case, and I say victim because he was a victim in the case, was also 13. And both young boys took the stand, and I was struck by how brave those boys were. And I knew that my client his identity had been mistaken. The young boy that was the victim was indeed robbed via armed robbery, but it was not by my client. And the pressure was palpable. For me, I kept looking around thinking that somebody was going to call a timeout because I was so confident that my client had not done it. But I went through the process. I proved my client's innocence in that situation. And that case was rewarding and memorable.
Well, we certainly haven't won the war on drugs, have we? Do you think that some of the crimes is increasing because of drugs?
What I can say to that is I see substance abuse disorder affecting a lot of my adult clients. I don't see it as much in the juvenile world, but it's there and it's a real problem. And I think that treatment and services and ways to rehabilitate are preferable than punitive.
We certainly had 3 witnesses, and they know you, and it means a lot to me. They know you personally. I chaired the hearing before, and I got out like 9 minutes of 1, so I had to run downstairs. And so I just want to say that you know, I really appreciate the time that you gave me. I think for your age, I look at your life experience. So you've lived through that life that these juveniles are coming before you, so you know. So you are a role model for them, that what they can do with their life, what you have done. And I really admire you. And to have, you know, this wonderful former judge to come and, you know, to talk for you and your witnesses. And I really appreciate it. And I thank you for all your time. And I'm very pleased that you applied. You did apply before. I'm going to ask you, did you think you were ready? Think you're a little young then? Let me put it this way. What have you learned since that time?
I think I'm always a work in progress and learning. I think I thought at the time I was ready, and knowing myself, I think even if I wasn't, I would have made sure I was ready. But I think that now I feel.
Well, I'm very pleased. I really am. So when you were going through, hard times, did you ever think someday I'd like to be a judge? Did it cross your mind? That's amazing.
Yeah, I don't think I thought that when I was a little girl, but I did feel it was important to do something meaningful with my life. I've always felt that way.
Well, good. Did it.
You know,
And it was really a pleasure to meet you.
pleasure to meet you.
Thanks, Councillor.
Yeah.
Councillor Iannella.
Thank you very much. Now, I read 90% of your cases are in state court. Now, does that mean all in the juvenile court, or some of the district courts, some of the superior court? What's the breakdown?
So I've had cases in all of the courts. I've always maintained a presence in the juvenile court. I've never left it, but I have practiced in district court and in the superior court.
And most of the cases in the juvenile court, are they private clients or are they court appointed?
At the time that I was practicing there, they were court appointed cases.
And I should have asked the judge there, of most lawyers who practice in the juvenile court, and most of those cases that these lawyers get, are they court appointed? I know people, there are going to be some private clients, but most.
I would say the majority are court appointed, especially with kids, because they're deemed indigent.
What's the most difficult cases that you envision in the juvenile court?
Like Judge Craven had mentioned, the juvenile court judges have the same sentencing authority, except for murder, as the superior court. So there's shootings, short of murder, everything is in the juvenile court.
Well, what about, again, I don't think maybe watching, maybe long time ago. What about removing kids from their parents? To me, would be like, oh,
And
would be the most challenging.
And I think that, to the extent that I implied that that wasn't the most challenging, I agree that invested with the authority to remove a child from his family it probably weighs the most on a juvenile court.
And what happens? You have like an investigator or a court officer, you have a lawyer, but who talks to the family? Somebody's appointed, or how's that?
Right, so the child has an attorney to represent them, the parents have attorneys to represent them, there's an investigator. It depends on their position, right. So everybody is represented, and there's an investigator on the case. And then oftentimes an evaluation where the doctors specific to juvenile court will evaluate the situation.
If someone, a judge removed a child to a foster home, is it drugs, is it alcohol, is it abuse, is there one thing that's more than something else?
I think each case you have to evaluate on a case by case basis. Serious abuse it can be, a cause for removal. The goal is reunification with the family, but there are times when a judge must remove a kid from the home.
No, I get that. When you say, I'm just curious, like, I know abuse, it can be physical, it can be emotional. Like, what's most of them like that? Is it physical, they beat up the kid, or emotional? I know every case is different, but I'm just trying to get a sense just for myself, like, what are most of these cases?
I mean, I think when the word abuse is used, it means physical abuse.
And at some point, if you send a child or children to a foster home, say there's more than one child, do they generally, I know it's different, do they generally go to the same foster home, or they go to different? One child goes here, one goes here, how's that work?
I think the preference is to keep siblings together and to maintain, to be have them stay in one place as long as possible. I don't know that that always happens, but that is better for the child.
I think so. And once someone goes to a foster home, a child, what is the role of the biological parents? Can they ever see the kids? How does that?
And again, each case is
Nuanced.
nuanced.
Have no idea.
Yeah.
This is a private kid, these are private, I can't go into juvenile.
Right, and the Department of Children's Families, their mission is to reunify. So that is their priority. And so, yes, parents can visit, parents can work towards, the judge can, and in conjunction with DCF can work on a plan to ensure the safety of the children so that they can be reunified.
And it's ever happened where the biological parents can, take the kids or children, even one child, back to the home for a couple of days? I can't do that.
That can happen. It depends on the case.
And does it ever happen, or frequently happen?
What?
The father parents adopt the children, that never happens. So
That does happen.
does that go in front of you, or that's another?
Yes.
And this is more knowledge too, you're very, just okay, and I'm almost done. And obviously it's easier if the biological parents don't object about the adoption. Is it frequent? It's really contentious, the hearing with the biological opposed to the adoption, or that almost never happens.
I think that it's fair to say that most biological parents object to termination of their parental rights, but there's so many different ways that.
It's so difficult.
Yeah.
You have 2 kids, you can only imagine.
It's true.
That would be such a tough. I don't have any questions. I'm impressed right from the start. Your parents, your mother's here today. What a work ethic, right from the start. You did a great job. She's a superstar, but she probably wouldn't be as much as a superstar if it weren't for at least you, because at least I'm meeting you tonight. And I'm applaud you for the work that you did. You're an outstanding parent. I mean, it's not easy, and you did a great job with her. Good to see Judge Reagan, the professor, my friend Steve DiFilippo, everyone else here. I was gonna ask one more question. Your husband gonna take you out to dinner when you go down here. As I told you, Councillor Kennedy, big supporter of you as soon as your name came before the council. He called me. You're gonna be a great addition to the juvenile court. I look forward to supporting you next week.
Thank you. I appreciate it. Thank you very much.
So Duff,
Thank you very much. Love speaking with you. Really had a great conversation. Thanks so much for your time. We all meet with everybody and have in-depth conversations. And so, and each of us comes to the council with different, life experiences and backgrounds. As I told you, I think Councillor DePalo is really more the expert on this court than anyone else in this chamber. Although I'm always open to learning. That said, one of the things we spoke about, and I'd like you to talk a little bit about it as you wish today, is young folks you see in your court right now as an attorney, but perhaps as a judge, who are members of the LGBTQ community, in the unique challenges and situations that they face and why you would. And I can expound on that more if you find it helpful, but what is, tell me a little bit about your experience with that community.
Yeah, so what I will say about the juvenile court as compared to other courts that I've worked in is that it's more evolved and informed than the other courts. Having said that, it could go further. Yeah, we all can, and we're all learning. And so you know, there's a recognition of LGBTQ rights and kids and how kids identify, and the Department of Youth Services does a really, does a good job of placing young individuals in the gender that they identify as. DCF has regulations it follows, and the judges, even the oldest of them, have gotten better at using pronouns and asking which pronouns the juveniles before them prefer, and so I think the court could continue to be educated and informed, and there's a very long way to go in that sense. The kids might come to the juvenile court having been isolated or alienated or abused by parents because of their gender identity or their sexuality. So it's something that we're confronted with, and we need to continue to stay on top of the research and make sure that we understand and check our own biases as those in authority positions.
Yeah, I agree with you. And I think it's, one of the things that concerns me is we see these kids and they end up in court, kids in this community, because some of them feel safer living on the street than they do in their own home or in foster care, which is like a whole nother level of problematic dysfunction, right? But it's real. And once that happens, we often see them fall into the criminal justice system. It can be through prostitution, it can be through drugs, it can be through theft, it can be through a combination of a myriad of things. But I find this particular population at such risk because the issues are so compounded why they're there in the first place. And being able, and I do think, to your point, I think our courts have done a really great job of educating and self-educating and becoming more aware, because a lot of this stuff is really hard to get your head around. Right. No matter how liberal or progressive you are or whatever, a lot of this is really tough stuff. But at the end of the day, it's real. Right? And we're the adults and they're the kids. And our job is to protect them. I always say, I don't have children. I don't have any birth children, but they're all my kids, right? I'm responsible for every single one of those children in that juvenile court as an officer of the court because I sit on this council. My responsibility is higher, and it should be. I should be held to a higher standard to make sure when I'm here questioning you, because you might become a judge, I should be held to a higher standard of accountability. I really, truly believe that. And some of the things that concern me is that we see, and it's not spoken about, so that's why I speak about it, elevated levels of in this community. Epidemics of birth, of young lesbians becoming pregnant or bisexual, whatever they identify as, having children out of wedlock. Not that wedlock matters, but you know what I'm saying. It's like they're having kids, right? And they're not prepared to have kids. They haven't thought about it. They're getting pregnant because they're not having safe sex. They're getting disease because they're not having safe sex. And so that goes into a whole other level of not just committing crimes or whatever. But I find it incumbent, and I appreciated the conversation I had with you on this, is that we are not, we all want to be compassionate and empathetic or sympathetic, but really understanding the complexity of some of these issues, because the fallout of them is so much. It's not just the immediate, it's a 5-level thing. And for you to do the work you do, thank you so much. I don't know that I could do it as long as you did. It's really, really hard work. And I do think your understanding of the juvenile brain is important because we know from science, and science is real, that the brain is not fully formed until the age of 25, right? It doesn't mean you can't have sex and have kids before that, but it does mean that the full maturity of your brain isn't really always there. Maybe maybe for some people it isn't, but we've seen the scope of it. So for me, knowing that you really grasp that, plus your lived experience, is critical for someone to be on as a judge in this court, because you can really change the trajectory of somebody's life, but you can also give them that gleam of hope that they might need. Because you never know that day, especially in court, that day that you're saving somebody's life figuratively, literally, especially with these kids. So I don't need to go on about this. You and I had a really, really great long visit. And I appreciate your time. I appreciate your dedication to these kids and to this particular court and field. Like I said, it's very, very hard work. Very, very hard work. I do my best to educate myself to understand, but it is like, there's so much. And it's constantly changing. And that's why I said I defer to Councillor DePalo on a lot of this, because he really, I believe, has the expertise more than anyone else in this chamber on that. But thank you for your application. Thank you for your answers. And thank you for listening to my recent diatribe. Yeah.
Thank you, Councillor DePalo.
Thank you, Councillor. Thank you, Councillor Duff. You're gonna make me, I have to look smart now. Like I know it.
Probably too hard. It's getting late.
Good afternoon.
Good afternoon.
Thank you for the work you do. It came up earlier. I know you applied in 2019 for a juvenile position. I don't know the exact timing. I know in Worcester we had a vacancy at that time that remained open for years after. So thank you for reapplying. And I want to thank the governor and her administration and her legal counsel team for, we're still early in the judicial nominations rolling out, but I'm very grateful that juvenile court has had a priority because it is so important. Being in this role, trying to find qualified people to serve on the juvenile bench, there's a challenge there. And we have a thin bar, I guess is the way I would put it. And I know that in your application, it was mentioned that you were working on an event that would encourage young listeners. Is that right? What do you think? Why do we have a challenge? And I know the answers, but why do you think we have a challenge expanding the juvenile bar?
Yeah, so I had worked with the Chief Justice of the Juvenile Court to put on an event. It was held at Suffolk Law School, but it was broadcast to all the other area law schools. And the event was to attract lawyers to the civil side of the juvenile court, though both sides are experiencing a shortage of attorneys.
Experienced.
Sorry?
I apologize for interrupting. Go ahead.
Yeah.
Experienced.
Exactly, because it really is a specialized court. And, I think part of it, all fields of, all disciplines right now are experiencing these shortages, but particularly the juvenile court. And the juvenile court before the pandemic, especially in Western Massachusetts, had a real hardship of the child welfare attorneys, a lack thereof. And they did everything from raising the rates to getting people to drive long distances. I think people don't understand it, and I don't think it gets enough. It needs a PR makeover, because when you go to law school, and for those of us that have, you hear about juvenile law mostly in the criminal realm, and you don't hear about the important work and the rewarding work of working with children on the civil side. So I think that there's been a lack of awareness around it. I think a lot of people think it's too emotionally charged and that they might not be able to handle it. But the attorneys that do work, especially on the child welfare side, find it's so incredibly rewarding. And I mean, what other job do you have where you can make a difference in a child's life, or get paid to go play basketball with them? And so it's unfortunate. I hope that we can get the word out, but
I appreciate that we all come with our own stories and experiences. I speculate that a lot of my law school peers had very comfortable upbringings and were never exposed to what many of the children who appear in juvenile court for whatever reason have gone through. And the room there is to help and make a difference in that area. And I know that, the legislature did add one juvenile seat in Worcester in the last few years. But of course, we do need more resources. I think it's the best place to invest because it's going to pay off the most in the long term. The Juvenile Detention Alternative Initiative. Was there any best practices to come out of your experience there, or promising practices maybe that haven't been implemented yet?
So there was an initiative within the initiative that I was a part of, and that was DYS was trying to find a way where they could divert kids sent to DYS. So they'd be held at DYS pre-commitment, and they were trying to get wraparound services in place and get the support of the court for them to divert the the also. So it was a diversion.
But how challenging is that? Is that practical right now with the resources we have?
It's challenging because of the amount of resources.
I have a particular concern that I'm going to raise, and I could raise it all over the state about any number of things. But just focusing for a moment on our second biggest city, Worcester. So in Worcester Public Schools, the children in foster care have astronomical dropout rates. I mean, like crazy dropout rates. And, having worked in education and with kids, court-involved youth, I know that like catching these kids and we're not going to turn them into Rhodes Scholars off the bat, but catching these kids and keeping them in school and seeing them through graduation isn't actually that monumental a task if we have people who are taking accountability to monitor the children. And there's all these different stakeholders. The school districts need to step up, the departments are involved, and of course the courts are involved. And I'm wondering, is there any room for the courts, strike that, is there anything you're seeing in the courts already? Or is there any room for the courts to be taking an active role in trying to piece together some level of accountability on someone's shoulders for tracking the kids, and seeing them through that process?
Yeah, so first off, I agree that needs to be done because like those stakeholders that you mentioned need to talk to each other and someone needs to take accountability because the kids slip through the cracks otherwise. Sure. So DCF might back off DYS is, housing the kids. So, but I've seen the court come along in terms of agreeing with this idea that the stakeholders need to talk to each other. And I do see that the First Justices doing just that. I know First Justice Terry Craven did that, and the current First Justice in Suffolk County. And the school to prison pipeline is real. And early.
What do you mean by that?
Well, I mean that if, for example, if a kid is kicked out of school, and there aren't, the odds go up, of them becoming court involved. And I think that.
Could I interject for one second? So like in the schools, we know LGBTQ youth are facing increased disciplinary actions. We know when we look at statistics that minority students are. And I love that expression, school to prison pipeline, I use a lot on the campaign trail. But I think of it a lot in terms of trauma to prison pipeline, as far as the trauma that's happening even before school, but including at school, where oftentimes it's exacerbated. I know that it's come up, one of your first questions you were asked, and I'll frame it a little different. If you were in the legislature, would you support expanding the age of juvenile jurisdiction? And I'm wondering, around brain development and what Councillor Duff said, is how does childhood trauma impact things as far as development? And how does childhood trauma impact your jurisprudence or your approach to serving on the bench?
So I think that the brain is evolving, that we've discussed a lot today, until the age of 21, and my kids know that all too well too, because I tell them that. But trauma can slow the process down even more. And so trauma-informed questions of the litigants, I think, is important for the judges to learn what that is.
Can I pause you again?
Yes.
So you gave, at one point, you administered the training that I believe every attorney who joins the panel has. It's called something like what every juvenile defender should know. Is that, I'm close enough on that? What should every juvenile defender know?
Well, in that training, if we were to run it today, would even have more about trauma. And also, attorneys need to understand that judges are receptive to hearing about trauma. So, even when the Miller case came down and the cases in Massachusetts that followed it, took a while for the judges to come on board and come around to it, and the attorneys to come on board. And I think that the same goes for trauma. So the more we know about trauma, the more attorneys will use it in their advocacy, the more the judges will hear it and become more informed, and how that plays out, whether that's a mitigating circumstance. But I think that trauma is.
Is there a trauma-informed approach to the courtroom that you take as a judge?
I think it depends. As an advocate, when you asked that question, I thought of a client that I asked the judge if they wouldn't mind coming to, we have these little side rooms right out of the courtroom, coming in there to talk to have the hearing in that side room. And I explained why, and that was based on the trauma of that particular child. And I think that there's a lot of room in the juvenile court for accommodations, and you have to present it to the judge. And the judge has to have an awareness of that it's a real thing, and hopefully act accordingly.
Yeah, I was glad to hear one of your witnesses talk about contempt in the courtroom, because I do think about that a lot in the juvenile court, in those rare cases when a juvenile is held in contempt. And oftentimes as someone like me might consider it problematic and lacking trauma-informed approach. So just last thing I'll say. So we haven't talked about CRAs really yet. And I know how many wonderful people we have in the system, and I know how hard we work and with the resources we have, but I'm concerned about the ones that don't go perfect, because we're striving to perfect the system, even though we'll never get there. So have you ever seen have you ever seen conditions placed on a child requiring assistance that you feel are counterproductive or not tailored to are likely to result in violations of said conditions?
Yeah, I've seen conditions in CRAs and in the delinquency session that can have the opposite of effect that the judge intended. A setup to fail, if you will, not tailored enough to the individual child's needs. And as an advocate, I think if confirmed with the judge, what I do if a program or a condition is not working is try to supplement it or change it or ask that it be removed. And I think that as a judge, if you see that a condition not having its full effect, you should take notice and wonder why.
Can I throw out a hypothetical lacking any context? So a child flees a group home. And they claim that it's because they were fearing for their safety because of another child in the group home. And I mean, how does one approach that? So the child comes before you for their hearing. This is part of the report. I mean, how do you approach that? Does that warrant escalating consequences one way or another? What does that warrant to you?
So, if first of all, I want to investigate what's going on at the group home, and you can do that a few different ways: through investigation, through bringing the DCF, the person that works at that group home in, because I happen to have the experience of knowing that these things happen at group homes, and I've represented a that was that we proved through video was assaulted at a group home. So it doesn't always happen, and kids can make excuses sometimes, but that wouldn't be ignored by me if I had that in front of me. And I think there's ways to get to the bottom of that. So an immediate consequence for the kid would be a depend situation. It would depend, but that hypothetical sounds like a common thing that happens.
Time to wrap up.
Thank you, Councillor. I'll ask no further questions then. Thank you for your time.
Councillor Jacob.
Thank you. Welcome. We had a robust conversation. I appreciate you coming out to North Adams to meet with me. And we talked about a lot of things. We started from a place of, I had not yet visited juvenile court, and I asked you basically to give me juvenile court 101 education, and you did, and I appreciate it so much. I had the opportunity this week to go visit the Springfield Juvenile Court and observe and meet with the judges and build on everything that you had shared and educated me on. One of the things we talked about at length that impressed me was the work you've done around racial bias and other biases. And I appreciate how much you've done, and it really does seem like you've availed yourself of so many different resources and continue to do that work. And I don't often hear someone talk about bias work to the degree that you have. Having said that, I welcome an invitation to come to the Harvard trainings on bias, so just pass that word along. Hello. But having said that, as a judge, and recognizing the implicit bias in our system, some things that are just systemically occurring before a juvenile comes through the system to the court, what, if anything, can a judge in the juvenile court do to affect any kind of change when racial biases are at play?
Thank you for the question. I think that first and foremost, a judge should do the work themselves and educate themselves and stay abreast of new information, including the data. I know from the data that children of color, Black and brown children, are overrepresented at every stage of the criminal justice system. And that awareness should inform my decision making. I know that kids of color are given harsher sentences than their white counterparts. I think it's 5 times. And so me knowing that, my colleagues knowing that, as a judge, if I were to be so fortunate, is a starting point. And then when making decisions, do the work to make sure that my personal bias isn't affecting the decision. And I believe that we all have biases, and implicit, explicit, and making sure that I'm not looking at the situation through my lens is how I would approach the situation.
So I appreciate that. And we also talked a lot about cultural competency, which is sort of a corollary, complementary area of interest. What do you think you can do to increase cultural competency in the juvenile court, if anything?
I think that cultural competence is important for all judges, especially judges that are presiding in courts where the young people before them are might not be the same race as the judge, and it's often the judge is white and the children before them are Black and brown, or children of color, and
language barriers.
and language barriers. And I think that, I think I gave you an example when we talked about cultural competence. It came from, I keep looking back to see if Delia's here, but I think she had to go teach class. But her client, young client, and this has happened to me, and I have a few examples as well, but brought their child to court. And the judge said to the client, that was her choice doing that. And I think that's an example of a judge maybe not having all of, maybe not having an awareness that there, for some parents, childcare is not an option. It's too expensive, or the daycare fell through. And so I would strive to have that radar on and make sure I'm not making these sweeping judgments. And I think that all judges in all the courts could continue to make sure that their consciousness is raised.
No, I appreciate that. Actually, that leads into, I wasn't necessarily even going to talk about this, but this is more a comment. I just want to make sort of a blanket comment based on both our conversations, but even more so having visited the Springfield Juvenile Court recently. Apparently back in the day, there was daycare facilities in these courts, and both from the standpoint of community members, clients or not clients, defendants or what have you, people who have to come to court and don't necessarily have childcare, and having young babies, toddlers to tend to while trying to participate and advocate for justice for themselves and for their family members might be, detracted from the needs of their kids, but also talking to the clerical staff in the juvenile court, the number of people, the pay is not very high, and childcare costs are very high, and the impediment to retention of staff because of the challenges around childcare could be so much benefited by having facilities in our courts. I think juvenile court is one, but I also think probate and housing were also ones where it was very clear to me how much of an issue it is. None of that is a question for you, but just commentary that I do think it's an area that's lacking in our justice system, and in terms of things like access to justice is such an issue, and I'm sure requires legislative intervention to bring on that kind of a resource. But I think it's so important to highlight that need and, if possible, find a solution around it. Having said that, I just want to underscore how much I appreciated our conversation, how impressed with you and your resume, your experience, but just who you are as a human and the lived experience that you've had, how much I value who you are and what you bring. And I very much appreciated hearing the witnesses you brought today and what they had to say as an addition. So all that to say, I'm wrapping up and don't need any further time, but thank you.
Yeah.
That was my turn.
It's your turn.
I think the most important thing is that the judge have a calm demeanor, that they never lose their temper. With that, I have one important question for you kids. Your mother ever yell at your father? You're not telling the truth. No, you've been great. You have great witnesses. You have great witnesses here. You got a great resume. You're going to be a great juvenile court judge. And as my friend, ex-councillor Juvenile used to say, when Ray Emmer was in the room supporting someone, they always get through. So,
Yeah.